Hello, I'm Siddharth Varadarajan, and today in the Wire Primetime, we will turn our attention overseas. Hearings took place yesterday and today at the International Court of Justice in a case Nicaragua has brought against Germany for quote unquote facilitating the commission of genocide by Israel in the Gaza Strip by supplying lethal weaponry to Israel and defunding the UN Relief Works Agency, which is the sole relief pipeline for Palestinians in the Gaza Strip who are now on the brink of famine. Nicaragua presented its case on Monday, and Germany got to counter that case today, Tuesday. We shall discuss in detail the legal arguments involved in the matter with Professor Heidi Matthews, who teaches international law at the Osgoode Hall Law School at York University in Canada. She joins us today from the UK. Professor Matthews has specialized in international criminal law and the laws of war. She has legal experience at the Special Court for Sierra Leone and the Special Tribunal for Lebanon. Her doctoral dissertation, From Aggression to Atrocity, Interrogating the Jus in Bello Turn in International Criminal Law, was awarded Harvard Law School's Leyland Prize. We're very pleased to be able to draw on her expertise for this topic. So welcome to The Wire, Professor Matthews, and thank you so much for joining us.
Thanks so much, Siddharth. It's a pleasure to be here.
Now, before we discuss the important arguments made by Nicaragua at the ICJ on Monday, I would like to take a couple of minutes to explain to our viewers the background to the present case. Following Hamas's attack on Israel on October the 7th, 2023, and the brutal killing of more than 1,000 civilians, Israel launched a full-scale military invasion of the Gaza Strip, which forms part of the Palestinian territories under illegal Israeli occupation. The Israeli assault, which continues to this day, has killed more than 33,000 Palestinians, most of them civilians, especially children and women. More than 3 times that number have been injured, and 1.7 million Palestinians are now homeless. That's roughly 70% of Gaza's population. In January 2024, South Africa moved the ICJ seeking provisional measures against Israel under the Genocide Convention. On January the 26th, the ICJ ruled that, quote, at least some of the acts and omissions alleged by South Africa to have been committed by Israel in Gaza appear to be capable of falling within the provisions of the Genocide Convention, unquote. Since the crime of genocide requires intent, the court noted South Africa's claim that genocidal intent is evident from the way in which Israel's military attack is being conducted, from the clear pattern of conduct of Israel in Gaza, and from the statements made by Israeli officials. And the court ruled that the facts of the case are sufficient to conclude that at least some of the rights claimed by South Africa and for which it is seeking protection are plausible. This is the case with respect to the right of the Palestinians in Gaza to be protected from acts of genocide. Regrettably, the ICJ's landmark ruling at this preliminary stage of South Africa's case has failed to deter Israel, which has continued its attacks on Gaza's civilian population. Moreover, Israel's main diplomatic and military backers, notably the United States and Germany, but also Italy, the UK, and others, have continued with business as usual, selling weapons to Israel despite the likelihood that this makes them complicit in the commission of genocide. I should note in passing that India too may have transferred military drones to Israel since the Israeli attack began. Now, on March 1st, Nicaragua instituted proceedings at the ICJ, again under the Genocide Convention, accusing Germany, which is the second largest supplier of lethal arms to Israel, of violating its obligations under the Genocide Convention in relation to the occupied Palestinian territory, particularly the Gaza Strip. Nicaragua also invoked the Geneva Conventions and their additional protocols. According to SIPRI, which is the Stockholm International Peace Research Institute, Germany accounts for 30% of Israeli arms imports over the past decade, while the US sold 69%. In 2023, according to the Forensis report on arms sales to Israel, Germany was the second largest supplier of major conventional arms to Israel, responsible for as much as 47% of Israel's total imports, following the US at 53%. Nicaragua argues that by providing political, financial, and military support to Israel, and by defunding the United Nations Relief and Works Agency for Palestine, uh, Germany is facilitating the commission of genocide, and in any case has failed in its obligation to do everything possible to prevent the commission of genocide, which is an obligation of every state party to the Genocide Convention. Let me now turn to our guest so that we may better understand the significance of the legal arguments here and their likely impact on the ICJ and the conduct of Israel and its backers. Professor Heidi Matthews, my first question to you is an obvious one. Germany is only the second largest arms exporter to Israel. Why has Nicaragua chosen to take them to the ICJ and not the United States? After all, Nicaragua has a history. It took the US to The Hague once before and won its case, even though it remained unenforced. So, what, in your opinion, are some of the reasons why Nicaragua has chosen to drag Germany to the World Court?
Yeah, thanks for that question. So really, it's a question of jurisdictional capacity of the International Court of Justice at this point, and so um, essentially, states need to have accepted the compulsory jurisdiction of the court in order for a case like this to proceed against it, and they need to have done so without having registered what are referred to as reservations to that jurisdiction, which would exclude the admissibility of a case in a given instance. And so in this case, both Nicaragua and Germany have accepted the compulsory jurisdiction of the court. It just means that they've consented to have legal disputes regarding the interpretation of international law or alleged violations of international law, such as the ones that Nicaragua has alleged against Germany. Both states have consented in this instance to have those matters determined by the ICJ. The United States has no longer accepted the compulsory jurisdiction of the court, and so back in the early 80s, when we saw the paramilitary activities case involving the U.S. and Nicaragua, the situation was a bit different. But right now, we see that the U.S. has not accepted that jurisdiction. Similarly, Israel hasn't as well. The thing that allowed, just so folks understand why it was the case that South Africa could bring a case against Israel that you've already described for us, that case is exclusively brought under the Genocide Convention, which has a jurisdictional clause which says that disputes surrounding the application or interpretation of the convention are to be resolved at the ICJ. I mean, we can talk about this a bit in a moment, but what Nicaragua has done in this case is it's brought really a much wider set of allegations against Germany than South Africa has against Israel, which is one of the really interesting aspects of this case. So that's kind of the jurisdictional legal side of things. I also think there's an expressive or political side of that question as well. Nicaragua, in its submissions yesterday, they're available online if folks are interested in listening to 2 hours of legal submissions, but they made a big point, as they did in their written application to the court. They made a big point of Germany's so-called raison d'etat of supporting Israel essentially unconditionally and more or less at all costs because of the obvious unique relationship between those two countries. And so I think there's an element here of Nicaragua as a state in the global South wanting to challenge the validity of that raison d'etat in 2024, which I think is important as well.
Right. If Nicaragua had wanted to confine its case to the Genocide Convention alone, Could it then have also made the US a respondent, as it were? Or has the US opted out of that?
No, I think so. Yeah. So, the no, I believe that I believe that that would be the case. I'd have to like double check the
Right,
legality of that, but I think that
right,
would be possible. Yeah.
right.
And the
Yeah,
allegation there would be a similar, it would be around complicity, and failure to prevent. We can talk about those
right,
two issues as well.
right. So, yeah, so essentially, I mean, the point you're making is that Nicaragua has sort of arraigned Germany on a wider set of charges, not just the Genocide Convention, but the sort of Geneva Conventions and additional protocols and international humanitarian law in general. That, of course, widens the ambit. It also complicates things, perhaps, and I'll come to that in a second. But for the benefit of our viewers, could you summarize what exactly is the nature of relief that Nicaragua wants from the ICJ? What are the provisional measures that it wants the court to indicate?
Sure. So Nicaragua has asked for 5 provisional measures. It's asked that Germany be ordered to immediately suspend all aid, but in particular, its arms trade with Israel. It's also asking that Germany make every effort to ensure that weapons that have already been transferred to Israel are not now used in the commission of serious violations of international law. It's asking for Germany to resume funding to UNRWA, in particular with respect to UNRWA's operations in the Gaza Strip. And it's also asking Germany to comply with international humanitarian law, kind of in general, and then finally to cooperate to bring an end to serious breaches of what's known as peremptory norms. That would include what Nicaragua alleges is a system of apartheid in the occupied Palestinian territory, as well as an illegal occupation that's violative of the Palestinian people's right to self-determination. So as you've noted, it really is quite a wide ambit of allegations here and correspondingly of relief sought. Just to note quickly, it's open to the court to craft its own set of provisional measures, right? So the court is not in any way bound to, if it decides to order provisional measures, is not in any way bound to what Nicaragua has requested,
Right.
and can craft its own measures as it did in the South Africa case in part.
So just to summarize, Nicaragua wants the court to tell Germany to stop selling weapons to Israel, to
Yeah.
ensure that the weapons already sold are not used for genocidal purposes or for the purposes of violating IHL or committing war crimes, and also to restore funding for the UN Relief Works Agency, which is, of course, the major lifeline for Palestinians in Gaza and elsewhere in the occupied territories.
That's right.
Yeah, right. Okay. Now, so this may be a minor sort of legal point, but let's get that out of the way. One of the, I mean, Nicaragua has also sought to become an intervener in the South Africa versus Israel case. Is that important? Why has Nicaragua wanted to do that? And will this pose a kind of legal challenge for it and for the court?
Yeah, so it seems like Nicaragua is really interested in being involved via the ICJ in the conflict in Gaza, right? And so the South African case, of course, is a totally separate legal proceeding from the one that it's instigated against Germany. Nicaragua has done something interesting with respect to the South Africa versus Israel genocide case. Historically, states have used Article 63 of the Statute of the Court. That's an article that refers to disputes around the interpretation of a treaty. And so it allows states to intervene to give their own interpretation of how a treaty should be applied by the court. But that's very different from the kind of intervention that Nicaragua is seeking here, which is to intervene through Article 62 and become itself a party to the case. That's something that's could very well, as you note, pose a problem, in particular because the court has discretion with respect to whether or not to authorize intervention under Article 62. And in many cases in the past, that sort of intervention has actually not been permitted. So we're in kind of new procedural territory with this intervention, and it will be interesting to see how that pans out. There may need to be, in fact, a whole set of hearings at the court to determine whether or not Nicaragua will be permitted to intervene in that way. But the broader context for this intervention is that states have done a lot of it recently, in particular in cases concerning the Genocide Convention. We see that with the Gambia's case against Myanmar. Several states, Germany, Canada, the Netherlands, etc., all intervening to sort of have their own say with respect to how the convention should be interpreted and applied. So it's kind of becoming a bit of a trend at the ICJ right now.
Right. So it's not out of the box. It's not nothing unusual that Nicaragua is trying to do. Others have done it. Perhaps the route they've chosen is unusual. But in the event of the court declaring that Nicaragua cannot intervene, that won't affect the case that it's brought against Germany, right?
No, it's a totally separate proceeding. Right. That's right.
Exactly. Great. Thank you for clarifying that. While listening to the arguments that the Nicaraguan side presented in court on Monday, I was struck by the fact that Nicaragua has sort of taken the October 7th bull by the horns, as it were, right? It sought in its submissions to actually contextualize the October 7th attacks on Israel, something that the Israeli side plus the US, all the backers of Israel have cited as the reason why Israel is doing what it's doing. Nicaragua has sought to contextualize those attacks, the October 7th attacks on Israel, by stating explicitly that an occupied people, in this case the Palestinians, have the right to resist. Mm-hmm. Now, given that the overwhelming victims of October 7th were non-combatants, do you think that this, how do you see this argument playing out in the eyes of the world at large, and in particular before the court?
Yeah, no, you raise a really important point. I was struck by that as well, watching the submissions yesterday. Nicaragua, and I think you're alluding to this, it didn't have to make that statement because it's not actually relevant, really, to the allegations it's made. In part it is, but mostly not. But what it's trying to do is to say, look, Israel is claiming the right of self-defense against Hamas in the wake of the October 7th attacks. And it's trying to paint the entire last 6 months of the assault on Gaza purely in terms of self-defense. And Nicaragua is saying, hang on a second, self-defense here. Certainly, they were going to say it's not a war of self-defense. And secondly, even if it was, self-defense just doesn't justify in any way, shape, or form violations of international humanitarian law, commission of genocide, etc. But partly, in order to reject the self-defense claim, Nicaragua did go quite far in the sense that it was willing to say that really the provocation here was on the part of Israel. And that's because of its claims, the claims that Nicaragua was making around the illegal nature of the prolonged occupation in the occupied Palestinian territory right now, right? So it's saying, look, this occupation has been going on for nearly 57 years. It involves systematic abuses of international law that violate the most fundamental norms that the international community has set up to protect folks. And so really the correct way of seeing this conflict, or this nightmare, to be frank, is to understand Israel as the aggressor and essentially Hamas as having acted in some sense in self-defense. I think it's important to note that Nicaragua qualified that, right? So it said, look, even if Hamas, as they asserted, was acting in self-defense, in other words, was resisting the illegal Israeli occupation, the imposition of an apartheid regime, et cetera, that resistance itself can also never justify attacks on civilians or other sorts of violations of international humanitarian law. So it said basically both things, right? It's trying to put Palestinian resistance on more of a level playing field with Israel's claims to self-defense. And I think that's an argument that's important, actually, to make in this case, and it helps us to understand the Israel-Palestine conflict more as an anti-colonial struggle,
Right.
and less as a another iteration of the 21st century war on terror or something like that.
Right.
So it's a very different way of understanding the conflict,
Right.
that I think is helpful.
Exactly. Now, the legal scholar Justina Uriburu has argued in a recent piece that adjudicating the claims presented by Nicaragua against Germany would also entail examining the legality of the conduct of Israel, which is not party to the Nicaraguan case, and that this might pose a challenge. Now, even if the ICJ, one could argue, is examining Israel's conduct qua the Genocide Convention, it is not examining alleged violations of the Geneva Conventions or international humanitarian law in general. I noticed in the oral submissions on Monday that the Nicaraguan side cited examples of violations of IHL by Israel. So, do you think this widening of the allegations is actually going to complicate matters legally, or will it help Nicaragua's case since the bar for violations of international humanitarian law and violations of the Geneva Convention are lower than that for genocide?
Yeah, it's a great question. So this is essentially the big legal hurdle that Nicaragua is going to have to face with respect to the ability of the court to act at all, right? And this is known as the monetary gold principle. It refers to a case from 1954 where the court said, look, if deciding on a matter between two parties is going to involve essentially deciding the legal status of actions of a third party state who hasn't consented to that judicial resolution, then the case is essentially not justiciable, right? So, Alain Perret, who's a renowned international legal scholar and lawyer, and who presented part of Nicaragua's submissions yesterday, was very dismissive of this principle, which I thought was interesting. He said, look, I never thought that it was useful, and I certainly don't think it's useful today, in particular because applying it in a case like this would essentially extract major violations of the most fundamental norms of international law from judicial oversight by the ICJ on the basis of the principle of consent. So it does pose a major hurdle, and the court has to decide whether or not it will apply the principle in the same way that it has in the past. And I think you're quite right to sort of to mention that the principle makes a distinction between allegations made under the Genocide Convention on the one hand and allegations about the wide range of other applicable international norms and laws on the other hand. And so it may be that those two sets of claims could be separated out,
Yes.
such that the Genocide Convention claims would stay and be adjudicated, whereas the much wider net of other claims would not be something that the court would be willing to address. So that just remains to be seen. But certainly the court's decision on that question will have a major impact for other cases that deal with these obligations, erga omnes. That's a strange Latin word that we use in international law to talk about obligations that are not just owed between a state doing a wrong and a state that's harmed by that wrong, but by indeed the international community as a whole.
Right. So the court presumably would have the freedom to, if it were to decide that it can't adjudicate on matters of IHL and the Geneva Conventions in this instance, since Israel hasn't been made a party, but at least to the extent to which it's examining violations of the Genocide Conventions, the court could separate these two elements of the Nicaraguan case and proceed on that basis. Correct?
That's right.
Okay. Now, when Nicaragua filed its case, 1st of March, there was a lot of consternation and skepticism by mainly European legal scholars, some North American ones, that who is Nicaragua to file this kind of case, and given that there have been well-founded concerns about the conduct of the Nicaraguan government itself within its own territory. We know that the UN Human Rights Commissioner has expressed concerns in this regard. Now, should the conduct of the Sandinista government towards its own people in Nicaragua impact how the world and the court views its case against Germany? Or is this domestic element quite irrelevant to the matter at hand?
Yeah, that's a really good question. That objection is certainly the first kind of political objection that you will see being raised of folks who are skeptical of this case. So they'll say exactly what you've said. Who is Nicaragua to, try and occupy this moral human rights high ground when it's clearly, not complying with human rights norms and standards domestically. Legally, that should not have an impact, right? So the legal questions that the court is asked to assess here are not contingent on a state's compliance with human rights obligations at home. Practically, we might see a different story. You would never get that in the reasoning of the case itself. But one never knows the extent to which sort of bias against, and I think it's fair to say,
Right.
bias against the global South states for violations of human rights, exist in international law in a very strong way, whereas violations committed by states in the global North, just look like business as usual. And I think that's part of what Nicaragua was trying to point out yesterday when it said, look, part of the major action that Germany has done that it says violates the Genocide Convention, among other things, has been to engage in this extensive arms trade, which has just been ratcheted up since the beginning of this genocide, of this war, and that just looks like international trade, right, in the eyes of international law. And that's what it's trying to challenge, right, is that actions by the global North that look normal actually themselves can constitute massive human rights violations. And so I think it really depends on the kind of frame or the lens that we wear when we look at human rights violations. And
I should note in passing that
yeah.
When Gambia brought its case against Myanmar, of course, that was South versus South. I don't recall reading angry comments about who is Gambia and what's Gambia's own domestic record.
Yeah.
So perhaps this is a political question, not one that should surprise us, has been raised, and may even be a factor in a verdict eventually, at least of some judges. But I think that you're right. I mean, the major fault of Nicaragua appears to have been to point a finger at Germany, which believes it's an upstanding member of the international community, and to call it out for complicity in genocide is something which would really have angered people in Berlin, the government in Berlin, and of course Germany supporters. Professor Matthews, turning to another question that is on the top of the minds of many viewers: would a positive verdict for Nicaragua be enforceable? And I mean, I know we're looking now into the future, although provisional measures have to be decided quickly, one way or the other. How enforceable would a positive verdict be? And if so, would the court's ruling be against only Germany, or would it have an impact on all countries that are selling weapons to Israel at the present time?
Yeah. So we won't see a ruling on the merits of the case for a very, very long time. These things take years generally to wind themselves through, but we will see a determination on the question of provisional measures. That question has a much lower threshold, right? So as you've noted already, with respect to the South Africa case against Israel, really what Nicaragua has to do is show that it's plausible that Germany is engaged in these violations and that provisional measures or a form of interim relief is required in order to protect the rights at stake in the period between now and when the decision on the merits is finally rendered. And so it's so even though a decision on the merits may not be in Nicaragua's favor, it could very well end up succeeding in obtaining provisional measures of some kind against Germany, right, in this case. And so just to be clear about that, those provisional measures are binding, which is a different question, as you've noted, from enforceability, which is the
Right.
capacity to actually like make those rights real in the world. The Security Council can be turned to assist in the enforcement of decisions of the International Court of Justice. Clearly we have a problem with some members of the Permanent Five who would likely, in all likelihood, resist that kind of enforcement. But decisions of the ICJ are really important for a host of other reasons, right? So they're persuasive from a political perspective, um, but they're also important for enforceability at home, right? So you can use a decision of the ICJ as persuasive evidence within the context of a domestic or regional court to say, it's been decided by the World Court, for example, that there is a serious risk of genocide, and therefore the actions you're taking are, in violation of domestic or regional obligations, not to be complicit in genocide, and certainly to prevent genocide. So I think, oftentimes we overlook the importance of how international judgments can be used in the regional and the domestic context as well.
Yeah, domestic legal as well as domestic political, right? Because
Absolutely.
this brings me to my last question. We don't have much time, but a Dutch court ruled a few weeks ago. I recall that engine parts for fighter aircraft must not be sold to Israel, and the Canadian government appears to be under some pressure to put a stop to the sale of lethal weapons. There's been some ambiguity. You noted in your tweet thread yesterday that there is ambiguity in the Canadian position. In the UK, where you are right now, there is a controversy over what legal advice the UK Attorney General has delivered to the government about Israel's violations of international humanitarian law, which would, of course, have a bearing on UK arms sales and other relations with Israel. Now, going beyond the success or failure of Nicaragua's case, could there be remedies, quicker remedies, in municipal law and or domestic politics in some jurisdictions that can put an end to the sale of arms to Israel at this time?
Yeah, in general, you mean like in countries outside of the German
Yes, of
context.
course. Yeah.
Yeah,
And even in Germany, I know that the Nicaraguan side made a reference to Germany's own domestic rules about the licensing of arms. I'm surprised, or perhaps somebody has gone to court in Germany and we don't know the outcome. But it would seem that from the sections that the Nicaraguan side quoted, Germany should not really be selling arms to Israel, even by its own domestic law.
Yeah, absolutely. And that's the case, really. That's a function of the implementation of international legal restrictions on arms sales in domestic contexts. And so we see that in many, many states, my own state, Canada, the United States with the Leahy law, as it's referred to as well, certainly within the context of European and German law. So, yeah, I mean, Nicaragua has called out Germany in part for failure to comply with its own domestic legal obligations. And there's a lot of litigation happening domestically across the world as well. So the Center for Constitutional Rights brought a case in the United States for the Biden administration's complicity in genocide. It was rejected on jurisdictional grounds, but the judge made some quite strident remarks about the need for the administration to comply with its own law around arms sales. There's litigation pending, at least one case in Canada that's being brought by a human rights organization in concert with the Palestinian human rights organization for many of the same reasons. There's a case being brought by the Global Legal Action Network in the UK as well. And so this is, this question of arms sales in the current context is unfolding in domestic legal context around the world. And I think, it's a question of tactics, really, for human rights lawyers who are trying to stop the arms trade to Israel, right? It's a question of what courts will bring the best success or the quickest success, and why. And it may be that for this is a bit speculative, but for states in the global north like Canada and the UK, for example, might have more likelihood of success than Nicaragua might have assessed with respect to its own courts, right? So one might imagine that calculation has already been made. Certainly, Nicaragua can't sue Germany in its own court, so it needs to go to the ICJ.
Exactly. At a time when there is all this talk of a rules-based order, self-serving talk of a rules-based order, I think the world owes some gratitude to South Africa and Nicaragua for reminding us about the centrality of international law, that the United Nations and its system envisaged a world where international law, international humanitarian law, the Convention Against Genocide, the Geneva Conventions would all mean something other than simply being words written on a piece of paper. And what we've seen through first South Africa's case and Nicaragua's case is some attempt to push the international system towards the enforceability of rights that everybody ought to take for granted, certainly the people of Palestine, who today are on the brink of famine, as per the United Nations' own assessment. Professor Heidi Matthews, we are completely out of time, but thank you so much for joining us for this very, very important discussion.
It's been a pleasure. Thank you so much.
Thank you.